I'm here. Can you hear me?
Yeah.
Yeah. Thank you.
Right. Welcome to the planning meeting for Thursday, the 27th of April at 4 o'clock. There's some housekeeping to do first, as usual. May I remind everyone present at this meeting is being live streamed as well as recorded via the internet, and this recording archived for future viewing. Could all participants mute themselves when not speaking in order to avoid any background noise or feedback when other participants are speaking? If a committee member wishes to speak, can they please put their hand up if they can be seen or use the raise hand function? If a committee member raises their hand via the function and is not subsequently invited to speak by the chair, please could they turn their camera on to indicate or place a message in the chat function. When invited to address by the chair, please could all participants ensure that their microphone and camera is on to ensure that they can be seen and heard when actively participating. If this is not possible for any reason, please bring this to the attention of myself and/or Democratic Services officers as soon as possible. If required, participants can dial into the meeting using a telephone numbers being provided on the invite. If for any technical reason any party to the proceedings is unable to hear, then the meeting will be adjourned for a short time to allow contact to be made. It's important to remember that all parties must hear all the proceedings unless they themselves decide to leave. Please ensure that all debate is raised verbally and not via the chat function for the sake of the recording. The chat function may be used to highlight any technical issues and/or to grab the attention of myself or Democratic Services officer only. Thank you for that. Right. Come to the agenda item 1. Apologies for absence.
I've had one, Chair, from Councillor Buckley.
Yeah, I haven't had any, and I'm not aware of any others. In that case, agenda item 2, minutes of the meeting held on the 29th of March 2023. Mark, you have your hand up.
Yes, there's a slight correction needs to be made on page 4 in terms of my declaration of interest regarding Uscall Dairy. It's not someone who worked, it's a relative. So change it to relative.
Noted.
Thank you.
Hopefully Democratic have noted that.
Yes, Chair.
Right. Just a relative. They don't work there. Yeah. Agenda item 3.
Can we
declarations.
Accept them?
Oh, sorry.
Yeah,
Accept
sorry,
the minutes.
Chair.
Yeah.
Yeah,
Sorry,
yeah.
you're right. You're quite right, Sir Ian. Yeah. Do we accept those minutes then? Anthony, you've got your hand up.
Yes, for item 3, please, Chairman.
Okay, yeah, I'll come on to that then.
We've
accepted the minutes.
Can I propose we accept them?
Yeah.
Yes, I'll second that.
That's great. Thank you very much, both.
Thank you very much.
Item 3 then, Anthony, you have your hand up.
Yes, Chairman, do I need to declare an interest if it's a delegated decision, officer delegated decision on an application? I'm not sure whether
because they're usually for reference. I'll
Yes.
take advice. I'll take advice though from James on that. I don't believe you do. I'm not getting a response from James. Any officer?
Can you hear
Marcus?
Me?
Yeah.
Chair?
Yes.
Yeah,
Marcus?
no, I don't think.
Who's that talking now?
James was talking. James, sorry. Do you want to
sorry, James. I can hear you
yeah,
now.
sorry,
yes.
Chair.
Yeah, I couldn't before. Go on.
No. Where the decision has been made on a delegated basis, there doesn't need to be a declaration.
That's what I thought. Thank you very much indeed.
Thank you then, Chairman. That resolves my query. Thank you very much.
You're welcome. Councillor Johnson, you have your hand up.
Thank you very much, Chair. With regards to item 9, small island buildings at Barry Biomass, Woodham Road, Barry, I've previously made public statements with regards to the planning application to which it refers, 2015-0031/OUT, and also I was present and voted on 1st September 2021 on the enforcement action which is being discussed and potentially changed today. I will of course be listening to all of the debate and interest and information provided at today's meeting with a fresh pair of eyes and making my decision accordingly. Thank you, Chair.
Thank you, Ian. Mark, Councillor Wilson, you have your hand up on this.
I would like to make the same declaration, not necessarily in terms of 2015, but certainly the last time in 2021 when I was on the planning committee and we discussed enforcement action. So obviously I will look at this with a fresh pair of eyes as well. So thank you.
Thank you. Councillor Hodges, I'm assuming it's the same.
It is the same, Chairman, although of course I voted on it in 2015 as well. Thank you.
Thank you. Councillor Perks.
Yes, agenda item 9. I've previously discussed this as a member of planning on Barry Town Council. And if I've discussed it on the Vale Glamorgan Council, I'd just like to declare that I have spoken on it. But obviously, I'm going to look at this with a fresh pair of eyes.
Where are we at? Councillor Bruce.
Yes, same for me. 1st of September. Oh, sorry. Didn't click on. 1st of September, I was on that planning committee as well. So I will look at it with a fresh pair of eyes.
Thank you, Gillian. Councillor Drake.
I have been on this committee where it's come to us from several times and have voted against it as well. But as I said, I will look at it with a fresh pair of eyes, this application. Thank you.
Yeah. Councillor Cave.
Thank you, Chair. Yes, I'm the same as the other councillors that have gone before me, that I've been on the planning committee since 2015, and this matter has come before the committee on several occasions. So I come today with a fresh pair of eyes.
Councillor Williams.
Thank you, Chair. Yes, and like others, I've been on a planning committee for some time and have actually considered this. I've also previously been a cabinet member of planning, so responded several times on that. But I will look at this afresh.
Thank you. Councillor Ernest, you have your hand up.
Yes, Chairman, I can't recall with respect whether we've discussed this in the current council or not. If we have, then I would need to declare like others. If we haven't, then I do not need to declare. Can I seek guidance on that, please, for the second time?
Chair, I believe that this enforcement notice was, and the enforcement action was discussed 1st September 2021, which would have been prior to the last election and the reformation of this as a committee.
Thank you for your help.
Thank you very much.
Councillor Johnson. Yes,
can I thank Councillor Johnson for his wise advice, sir?
I too have to add my declaration similarly to everyone else, in that I've been on this committee since 2017, and this has come up a number of times, and I have spoken or have been part of voting on it, but I too will look at it with a fresh pair of eyes. Councillor Hodges, you still have your hand up. Is that legacy or is that something new?
Just
Thank you
struggling
very much.
to get it down, but there you go. Thank you.
There you go. There being no other declaration of interest, we can move on to agenda item 4. Now, on this item, I'm proposing we defer this as it needs to go back to Cabinet, and it's due to go back on the 11th of May. So this has actually been brought to us prematurely, and we need to consider it after Cabinet has seen it again and we see the final iteration. I hope that can go through with no one against. I see no hands. In that case, this matter's deferred. The Vale Glamorgan Local Development Plan 2011-26, supplementary planning guidance, etc., is deferred to a future committee meeting. We will consider it then. Thank you all. Agenda item 5, building regulation applications and other building control matters determined by the Head of Sustainable Development under delegated powers. This is for noting. Moving note.
Happy to note, Chair.
Yeah, see no dissent. Agenda item 6, planning applications determined by the Head of Sustainable Development under delegated powers. There's 2 is for noting.
Happy to note, Chair.
Thank you. And agenda item 7, appeals. Ian Robinson. I think this is.
Thanks, Chair. Yeah, there are two appeals on the in the report. The first one relates to refusal of permission at 51 The Parade in Barry for large Velux roof lights and like a Cambrio window. So I'm not sure if members are familiar with that kind of thing, but it's where you have essentially what looks like a roof light when it's closed, but it can open up essentially to create like a little balcony in the roof. So that was refused due to what we saw as being a harmful impact on the character of the building, and consequently the conservation area that it sits within. The building was recognised in the conservation area appraisal as a positive building. And the inspector agreed that whilst there was an existing small roof light on the front roof plane that was fairly discreet, and what was proposed would have been quite a significant intervention into the roof, and that would have a harmful kind of appearance on its traditional character. So that was dismissed. And then the second one relates to the refusal of advertisement consent for a large illuminated signboard on Cardiff Road, just down from the Texaco petrol station. One of the kind of big screen, rather than being like a static or hoarding that we're used to seeing, a big electric screen with the images that would change, and that was refused initially because officers felt it would have a harmful impact on the character of the area, and the inspector agreed and considered that although this was a kind of a mixed context, largely commercial in terms of the surroundings, that didn't justify a sign of this size and nature, which would appear incongruous. So that was dismissed as well. Those are the only two on the report, Chair.
Thank you, Ian. That's for noting again.
Happy to note, Chair.
Thank you. No hands up. We move on now to agenda item 8, trees, the delegated list. Again, for noting. Yep, I see hands up, people moving to note. Yeah. Councillor Bruce, you've got your hand up.
Yes, and I see that there are several trees that have been approved for partial reduction, branches, etc. Should approval of trees be allowed at this time of the year, with many birds nesting, eggs in nests and fledglings, etc.? There's no actual date when they can or, when they should be removed.
I think perhaps Ian, you should respond to that.
Yeah, so what we'll typically do is place an informative on any consent we grant for doing work with trees, to draw the person's attention to the fact that they should do everything they need to do to ensure they're not affecting nesting birds prior to carrying out those works. So there's nothing technically to stop them doing the works in this season, provided they satisfy themselves first that they're not going to be affecting any nesting birds. Yeah, so that's why we don't kind of restrict.
Thank you. Yes, there's no actual date on this, so that's fine. That's great. Thank you.
Yeah, thank you very much. Thank you for that, Councillor Gillian. Right, we move on to agenda item 9, enforcement action, land and buildings at Barry Biomass, Woodham Road, Barry. Ian, this is for you to take us through.
Thank you, Chair. Yes, I will do. Thank you. I'll first just draw committee's attention to the fact that there's a couple of matters arising on this report. So those are representations submitted firstly by the Docks Incinerator Action Group, DIAG, and secondly from Barry and Vale Friends of the Earth. I'll just summarise kind of the key points made from there. This isn't to say this is an exhaustive list of all points made, but members have had the comments in full circulated, so I don't propose to read them out in full. In summary, the DIAG comments, they make some points relating to public speaking on this kind of matter at planning committee, and how this isn't allowed in the same way that it is on planning applications. The development should be described as an incinerator rather than a wood-fired renewable energy plant or similar. The planning department are in a rabbit hole. The development falls within Schedule 1 of the EIA regs, and consequently the 2015 planning application should have been accompanied by an EIA. Planning permission shouldn't have been granted in the absence of EIA. The committee are being asked to support a planning permission that's not lawful. there's not case law that demonstrates how this kind of matter would be remedied. There's reference made to extracts from the appellant's representative's letter to PEDU, PEDU's letter to the Vale, and the Vale's response to PEDU. It suggests that the extracts from those letters suggest there's collusion between the council and the appellant, and the council should make sure there's sufficient expertise to review environmental statements, and that the matter should be deferred from planning committee. And then the Friends of the Earth representations are similar in a number of respects, particularly in respect of kind of the matters of EIA. But they also comment on public speaking. They also refer to a number of points relating to kind of the acceptability of the development in relation to kind of flood risk and drainage and noise, and whether there's a waste planning assessment being carried out. A number of the points made in the matters arising are very much kind of relevant to the merits of the development that's constructed, and in that respect are very relevant to the existing planning applications that we have before us, and the appeal that's ongoing. I just wanted to flag for members' sake the kind of this distinction between those issues and what the subject matter of the report is this evening. So the subject matter of the report is how the breach and the requirements to remedy the breach are phrased and structured on the enforcement notice. So where there are points made in relation to the acceptability and the planning merits of the development, those don't really go to the heart of what we're discussing tonight, which is more of a legal matter as to what the enforcement notice should say, based on the kind of the situation on the ground. On my response on the notes, you'll notice I refer to legal advice which the council was seeking just to confirm previous advice, and I will come to that. We have received that, so I will come to that, but I think it makes more sense if I go through some of the main issues, and I'll touch on it then. Councillor Champion, sorry, did you want to make a point? Oh, sorry, I'm not sure who was first. Sorry, I can see a number of hands up. Would you like me to stop there, Chair, and you leave it to ask members' queries? You're on mute, Chair.
Chair.
I apologise. I'm curious to see what Councillor Johnson and Councillor Champion want to ask, although I'm aware that you haven't really started your introduction properly yet.
If I may, Chair, it's really it's a point of order regarding public speaking, planning, and the reasons for members of the public who tried to register for this meeting to speak on the enforcement action notice not being allowed to speak to us today. Thank you, Chair.
Okay, that's I guess that's, oh no, it's not Councillor Champion's point as well. On that point of order, can you respond, Ian, please?
Can I defer to James or Mark on that? It's a procedural.
Yeah, Mark, James, perhaps you're right. James would be more appropriate.
It's a query that's come up before. The guide to public speaking at planning committee is limited to planning applications and not enforcement matters. So we don't tend to. There's no provision for members of the public to speak on enforcement matters. That's limited to planning applications.
Councillor Johnson, you have your hand up again.
If I can, Chair, I mean, I think that's very disappointing. I appreciate the that this isn't the as Ian was just explaining. This isn't obviously the full discussion. This is regarding technical points regarding the enforcement notice, but I think it's still disappointing that members of the public aren't allowed to speak on this matter. I think, although I don't know that was, perhaps by omission when we were drawing up the guide to public speaking, because we assumed that people wanted to speak on an initial planning application rather than perhaps on an enforcement notice. But given the relative frequency at which enforcement notices come forward to this committee, it does seem to me to be both an omission and a mistake, that people aren't allowed to speak on those, and I think that we are missing something by not allowing people to speak on it today, particularly given the importance of the issue. Thank you, Chair.
Thank you, Ian. Marcus, you want to respond?
Thank you, Chair. Just to clarify, it's not an omission. It was clearly a decision taken around appeals and enforcement notices and action that the right to speak could be taken. They are a lot more legalistic than sometimes than planning applications, and they can open the council up to issues of challenge around comments that can be made. So the decision was taken on the advice on advice when we originally brought in powers to speak. So just to clarify, that's not an omission, and also to make it clear that obviously the public were able to speak when the planning application to which this enforcement notice relates was brought to the committee, and indeed there are planning applications in now currently, and that would be the proper time for the issues raised and the public's issues raised to be considered when and if those matters come before a planning committee. So just to clarify, that is not an omission. It is obviously this guidance and the protocol has been reviewed, I believe, at least once, and it has remained in the format allowing for comments to be made around planning applications, of course, where consultations take place. And remember, with enforcement action and legal action, there is no process of a consultation taking place. That process that is usually enforcement action taken against unauthorised development. So that is the reason why we haven't allowed public speaking on those matters, and it isn't by omission.
Thank you, Marcus. Mark, you want to contribute as well?
Yeah, just very briefly, Chair, just to say, obviously, because of the legal decision that's been made, the interested parties that did wish to speak were given an opportunity to provide written representations, which obviously have been included in the matters arising for members' view.
Absolutely, thank you. Councillor Johnson,
Yes,
last thing on the thing.
Yes, thank you very much. I don't want to prolong the debate, but I don't recall, Marcus, I don't recall being provided with any information regarding that being a reason for it not being included when we reviewed this last or previously. So I'd just like to have it noted, whether it's verbally here or in the minutes, that I'm concerned that we have not allowed it on this occasion. Thank you, Chair.
That's noted. That's noted. Thank you very much. So moving on, back to Councillor Champion. You had your hand up. You've taken it down again. Was it? Has the matter dealt with? Yeah. Thank you. Right, moving back to Ian Robinson, if you'd like to carry on.
Thanks, Chair. Yes. So, yeah, I mean, obviously, all members are aware that this is a matter with a lot of history, and it's technical and quite complex. So I will try and sort of set out the kind of the basic but relevant detail that does justice to that, but not go on too long in terms of the very fine detail and minutiae. But obviously, any points that members need clarification on, please feel free to raise that afterwards. I'll just go into a bit of background. As referred to earlier, this matter was reported to Planning Committee first in relation to the enforcement in September 2021, where authorisation was given to take enforcement action, and then the notice was served in September 2021. Just for clarity's sake, I'll just read out what was on the notice that was served. The key things being the breach and the steps required to remedy the breach. So the breach was referred to as being without planning permission, the carrying out of operational development comprising the construction of a wood-fired renewable energy plant together with associated structures on that part of the land edged green on the plan. And then there's a second point which related to the material change of use of land to the north of that site. What we're talking about tonight doesn't deal with the land to the north. It's about the main part of the site to the south of that. The requirements on the notice were to permanently cease the operation of the renewable energy plant, including the carrying out of any performance testing, permanently remove the renewable energy plant, including all buildings, plant and associated equipment from the land, and then it referred to ceasing the use of the land to the north, removing containers and vehicles from that land to the north, and restoring the land afterwards. When that matter was reported to committee, the reasons given for taking the action was that the plant did not accord with the plans that had previously been approved, and failure to regularise the situation could lead to the development on the ground becoming immune from enforcement action and then capable of being operated without the control of the conditions that were on the planning permission. The report didn't seek to argue that there was something fundamentally unacceptable about the development. It was about the ability of the council to enforce the conditions which were placed on the planning permission. Now, recently, following the appellant's representative's letter to PEDU in February, and for the avoidance of any doubt, PEDU are the formerly the planning inspectorate. They're the body that will be dealing with the appeal. PEDU wrote to the Vale of Glamorgan asking for the council to give further consideration to how the breach is kind of phrased on the enforcement notice and consequently the appropriateness of the steps that go with that. So I'll just read briefly that part of the letter from PEDU, just so members are clear on why we're back at committee tonight, asking these questions. PEDU's letter said, in this case, it is important that the allegation accurately describes the breach of planning control, not least given that it defines the basis of the deemed planning application that falls to be considered under the Ground A appeal. It also has significant bearing on the requirements of the enforcement notice and the associated appeal on Ground F. The inspector therefore invites the local planning authority's comments on the implications of its stated position on the nature of the breach of planning control, on the description of the allegation in the enforcement notice. It should consider whether the allegation is a sufficiently precise description, if not, how it might be corrected, and whether such correction would give rise to injustice to any party. Comment is also invited on any consequential effect on the scope of requirement 5.2, and 5.2 was the steps taken to remedy the breach. It may be necessary to seek legal advice, and they gave a period of time for that to be considered. So the council then wrote to PEDU to say that we felt this was a matter of such importance that it needed to be considered by planning committee, notwithstanding any process that might normally be in place for the planning department under delegated powers to kind of correct things on a notice. So the key point here is that we feel that the 2015 consent is extant and was implemented, and by implemented I don't mean constructed in full in accordance with the plans, because I think we're saying clearly there is a difference between what was constructed and what was approved, but it was about the fact that it was commenced in line with what needed to be done to commence it. So the prior to commencement of development conditions were discharged, and then piling in the first instance, the commencement of the development occurred in accordance with that 2015 consent. Now, clearly at a point after that, a different path was taken in the completion of the development. But the fact that the 2015 consent was, in our view, implemented has bearing on what the enforcement notice should reasonably say and tell the developer to do. So the enforcement notice can't remove the planning permission and take it away from them. So where a planning permission is implemented, it is legally the developer's right to revert to what they have planning permission for, even in this case where quite clearly that would require really significant works to take away certain items and change things to put it back to the approved plans. That is still their right. So that is kind of the basis of the report this evening, suggesting that actually for this to be an appropriately worded notice, which gives the developer the legal options which it should have, the breach should be worded slightly differently, and there should be a further option in terms of the steps to remedy the breach. So I'll just read through from the report the suggested amendments to take account of that. So it is suggested that the breach on the notice should reasonably be described as carrying out of operational development comprising the construction of a wood-fired renewable energy plant together with associated structures, not in accordance with the details and plans approved under planning application 2015 031/out. I.e. it recognises implementation of that, and subsequently then the requirements would include the option of carrying out the development in accordance with those plans. So it's not taking away the requirement to remove it. it's not kind of backtracking or reverting to a situation where we're saying what's been built there has permission or can be allowed to operate. It's saying that there should be an option which affords the developer the right to revert to what has previously had planning permission granted. And at this stage, I'll just refer to the kind of the further legal advice which we sought on those points. So there's a few key questions which we asked our own principal lawyer and subsequently the barrister who has given advice on this matter. And the first question was, can the 2015 permission have been implemented in the absence of EIA? And it's clear that the matter of EIA is one of huge importance and a huge amount of interest publicly and to officers and to members. The legal advice is that no, just because there wasn't an EIA there, that doesn't mean the planning permission could not have been implemented. And adopting the suggested amendments to the notice as set out in the report is not making a judgment on whether EIA was or wasn't required. It's not making a judgment on the acceptability or the merits of the planning application. It's really just reflecting the fact that the 15 consent was implemented. Just briefly, the second question was, in the event that the permission were implemented, is the wording that's proposed in this report now to refer to non-compliance with those plans and to give the option of reversion to those plans, is that the appropriate approach? And the legal advice is yes, that is the appropriate approach, and the notice should be doing that. And the third point we posed was, does the proposed amendment to the enforcement notice does not require consideration to be given to the merits of the extant 2015 permission or its compliance with new legislation or policies? And what we're saying there is that doesn't suggest that any applications to amend that 2015 scheme shouldn't be considered in light of current legislation and policy, which is what the new application will do and what the ground A appeal will do. But what it's saying is this isn't a matter of judging the merits or acceptability of that 2015 permission. It's about it's about what is the correct approach on the enforcement notice, having regard to the implementation of the consent in the first instance. Right, I think that covers what I wanted to say. I can see Marcus has got his hand up, so I'm happy for Marcus to supplement that.
Before I call Marcus in, so to clarify, what we're being asked to do is to vary our enforcement notice in the light of the comments from PEDU and the advice from barristers.
So what the report proposes is not that the council would itself modify the notice, but the proposal is that the council would respond to PEDU to give comment as per PEDU's request, to note that the council feels it is appropriate to amend the breach and the requirements as set out. That's the recommendation before members this evening.
Yeah, thank you very much, Ian. Marcus, you want to comment on this before I open it up to discussion?
Thank you, Chair. Yeah, and it was just to explain, and Ian's done a really good job of explaining the background to that. And I just wanted to say that obviously, when the first enforcement notice was agreed in 2021, at that point, we did not have clarity on whether this consent had been implemented. So that is something that led us to actually prepare a notice in the way it was prepared. At that time, the legal advice is that was the correct way to prepare it, as is quite often the case with enforcement matters. Substantial amounts of information come in the time between when a notice is served and when, for example, an appeal is submitted and when that appeal is going through its procedural process. This is what's happened in this particular case. Obviously, it's run for nearly 2 years already, I just wanted to make that point that it is not unusual for inspectors or for the planning inspectors to come back to the council and say and suggest amendments or changes to a notice, albeit they do have the powers to make those changes themselves when they're considered, but they often will ask the council to consider those as well as part of the process. Ian did allude to the fact that in most cases we do deal with those through delegations, which we have to officers, but obviously given the nature of this particular enforcement action, it was felt appropriate to bring this matter back to council, back to full committee for consideration on the basis of the legal advice that we've now had, that the initial piling was in the correct place and therefore that the consent was implemented. it's important to note actually that the developers of this scheme had failed to engage with the council in any meaningful way up until the point when the enforcement notice was served, and it's only since that point that they have engaged over a number of matters, and when a flurry of information has come in since then, which they've sought to establish the facts, and of course they've also provided environmental impact assessments since that time as well. But I think it's just a bit of background really around that as to why we're in this position. This is not unusual. It happens quite often. It is often the case that formal enforcement proceedings and action will stimulate a response from developers where we may have to, and that itself leads to a fact where we may have to amend things just to accord with what is the situation on the ground. So I just wanted to make that point.
Thank you very much, Marcus. I think the first hand up I'll open it now to general discussion, but first hand up is Charles, Councillor Champion.
Thank you, Chair. Is there a legal difference between an incinerator and a wood burner, or is it just semantics?
I mean, in my view, there's, and this is my opinion, you could describe the development in a number of ways, in the same way that you could describe an extension of a house in a number of ways. So the technology involves incineration of a gas which comes from a process having had the wood inputted to it. So in that respect, yes, it incinerates. It's also a plant which generates energy from wood. So it's in my opinion, there's no right or wrong to how it's described. What it is what it is. I know some parties will say it should be described as an incinerator. That's the most accurate way of describing it. Now, arguably, calling it an incinerator might mean that there is a level of misunderstanding about what the process is. I think to many people, calling it an incinerator, you might imagine it's simply the burning of solid waste rather than the type of process involved. I would say one person would have a different view than another on what the most appropriate way of determining it is, but that doesn't change fundamentally what the development is.
Thank you.
Marcus, you wanted to come back on that as well, I think.
Yeah, just to add to what Ian said, obviously different legislation will have different meanings in different legislation. So in this particular case, the plant was applied for and sought grants or the consensus to put energy into the electricity into the system under the renewable energy scheme, and that is a UK government based scheme, and that was granted to biomass. So that is partly why I think that it's key to their description is that from a planning perspective, as Ian has described, there is really very little difference. There are slight differences when you look at the environmental impact assessment, for example, as to what each of these things are. But the reality is that the biggest reason that they will have used the term biomass is that it would meet the terms of the renewable energy tariff, and it would have been they secured their buy-in, their electricity price on the basis of that. So just wanted to, it is largely, I'm afraid, semantics from a planning perspective, but from other related legislations perspective, it's not. It's really, really important for them. So that's probably the reason why it occurred.
Thank you, Marcus. Councillor Johnson, you have your hand up next. Ian.
Thank you, Chair. Thank you for the introduction there from Ian and additional material from Marcus. I've got just a couple of questions, and I'll, which I want to ask now, and then maybe come back with further comments later on in the discussion. One of my questions was regarding the statement of common ground and how we reached that point, because obviously that was done under delegated powers by officers following the enforcement notice in September 2021, but the statement of common ground obviously wasn't reached until November last year, and we had a very short reference to it within the briefing, but obviously it wasn't come back to councillors to discuss, and that is relevant, I think, to the the principle of it, which is around the 2010 and 2015 applications that were agreed by committee, or by inspector and by committee respectively, about the principle of the plants. And also I was just looking to understand, because of the nature of the correspondence between ourselves, the appellant and PEDU, and the fact that the inquiry has been postponed. Obviously there are people who are concerned that there is that has impacts on timeframes and things like that. So I'm just wondering, what impact, if any, this potential change in the enforcement notice has on the wider discussion that's taking place, and also, therefore, within that, also the what the statement of common ground does to that wider discussion and public inquiry. Thank you, Chair.
Okay. Thank you, Ian. That's a good question. Ian Robinson, please.
Yeah, that's fine. I'm happy to talk about the statement of common ground. I would just say, in my view, the issues leading to it and the nature of it is not fundamental to the question that is the subject matter of this report, which is all about what the wording is. However, I'm certainly happy to talk about it. The statement of common ground was raised at the briefing session, and that was one of the main reasons for the briefing session with members, not just to give members an update on where we were and what the next steps were, but to talk about that. And my recollection, my opinion, that the matter of being asked to sign up to an in principle preliminary statement of common ground was covered quite clearly, I think, in the briefing session, and officers weren't prepared to sign any statement of common ground without having had that briefing session to discuss that issue with members, and make clear what the rationale would be for it. It wasn't a matter that was voted upon like a planning committee, but it was the purpose of the briefing. What the preliminary statement of common ground says is that a development of this type is acceptable in principle in this location. So it's not saying that this development is this specific development, this specific technology, a development of this size. So again, that's why I don't feel personally that the content of the statement of common ground is really relevant to the key question tonight, which is, should the enforcement notice reasonably give the developer the opportunity to revert to their development? That's kind of a matter of fact. It's a legal matter, really. So I don't think there's a great deal of overlap in the two. In terms of PEDU and the letter, so it's up to them to run the appeal and on the timeline they see as being right. So I think when the letter was received from the appellant's representative, they felt they had questions for the council, which is obviously the purpose of tonight, and that meant that the timeline they previously set out couldn't be kept to any longer. I don't know what the exact implication would be for what the knock-on effect would be in terms of how long subsequent stages would take place. I mean, I believe it is up to PEDU to deal with that as they see fit. So if PEDU were to be of the view that they feel the planning applications should be determined before the matter goes to inquiry, my understanding is they've got the right to do that. Now, they might ask us for our opinion on that, and ask the appellant for their opinion on that, and that's something we can talk to we would talk to members about. We'd have to make sure that what we responded to PEDU with was what we felt was in the public interest and in the council's interest. So that, but my understanding is they're not bound to do what we said. So if we, the council, went back to them and said, well, actually, no, we don't think you should defer delay the inquiry till after the application's determined, they may still be able to do that. But I couldn't guarantee whether they would do that or not. Does that answer your question, Councillor Johnson, on the PEDU point? I couldn't recall whether there's a secondary part to it. Sorry.
I think that probably answers what I was driving at, which is about the timing of the inquiry. But yeah, if there's further points, I'll come back later, obviously. But
okay, yeah. Just on that, sorry, in the obviously the correspondence between the appellant's representative and PEDU with the council subsequently, and this is touched on in DIAG's representations, which I referred to earlier. There is a I don't know, an implication possibly in the way that, or an inference in the way that the appellant has worded their letter, that, well, there seems to be taken to have been an inference by some parties that that implies the council has agreed that X, Y, or Z will be acceptable and will happen. I say that because the representations I referred to earlier suggest there's been collusion between the council and the appellant. So for what it's worth, I just thought I'd reiterate that that's not the case, and any advice given to the developer about the ability to regularise the development is purely related to the process that in principle allows the opportunity for that to happen, but not advice to say we believe this will happen, we believe it will be acceptable. All the advice has been very straight back in terms of just what the process is.
Yeah, thank you, Ian. I just said that I think the paragraph referred to, from our officer, I think says makes those points in a way that seems very clear to me that we haven't made a decision upon that, and for me the inference is that the appellant is, as you say, suggesting that these things may be regularised, but certainly not that we've agreed to that. Thank you.
Yeah. That's exactly it. It's about this enforcement notice and making it more robust, I think. Councillor Perry, you have your hand up.
Yeah, good afternoon. Yeah, just a quick clarification on what Charles Champion just asked. You mentioned burning of biomass and then gasification. So what's actually being burnt is gas rather than the actual wood itself? Yeah.
That's right, yeah.
And biomass suggests that it's a natural material, sustainable, but I believe it's pellets that are gasified. If those pellets aren't 100% made from wood and there's contaminants in there, such as paint or any other material that's not wood, it's not then 100% biomass, is it? It's partially biomass.
So, I mean, NRW are the principal, regulator of the development, and they will grant a permit in principle. They can grant a permit for certain activities, and they will have requirements about what the composition of the inputted material must be. Now, I would say that permit is very unlikely. I haven't got it in front of me, but I don't believe it says it has to be pellets. It'll be more general requirements about the nature and makeup of the material. I agree with you. There would become a point where you say, well, actually, the input into that system isn't that, and then if that happened, imagine if the plant were operational and that happened, then they would be in breach of their permit. But they have a permit for doing a certain thing, and that's what is assessed.
Yeah. So, and we don't know where the wood's coming from. There's no fixed chain of supply.
I don't believe so.
No. So
it's wait. I mean, yeah. Just to add, Councillor, they describe it as waste wood. It is part of, if you like, the recycled product. Now, for us, as you rightly point out, they've classed it as biomass, and they've obtained a feed-in tariff license on the basis it's biomass. But that's not a part of the planning process. So we're not involved in that process. They will have obtained that license from BEIS via the application they will have made probably back, because I think it's changed now, quite some time ago. I'm sure they made their application just before the changes to that system. So for us, we rely on Natural Resources Wales to confirm the licensing and the control of what goes into that plant, and indeed what comes out too. So it would be for them to comment on what they felt was the appropriate feed source and feedstock for supplying it. It's important to note that they've applied for a specific type, which is waste wood. They haven't actually stated it's pelletized, but I understand that it may be pelletized. We haven't had that clarified, but that would be for Natural Resources Wales to determine, and how that process runs, as Ian said.
For the benefit of the rest of us, what's pelletized?
Pelletized means that.
Oh, pelletized. Sorry.
Pelletized, not pelletized. Pelletized. Yes,
I misheard. I'm sorry. Pelletized. Yes, I understand now.
Yeah. And so I've just been sort of reading through what's come through today. Should prior to determination that we've recognised that it was Schedule 1 or not? Was a mistake made there? Because obviously we seem to be made some sort of mistake today, but when it went through to the planning committee before, was there a mistake made in not having an environmental impact assessment and having it as Scheduled 1?
Do you want me to? I'll deal with this if you
yes,
like.
Please, Marcus.
Okay,
yeah.
So we have gone through this, and I don't really want to dwell on it if I can, because obviously the need for an EIA or not is not relevant to what you're considering today, because as Ian has said, when we've spoken to a barrister, the fact that the EIA wasn't done at the time of the 2015 consent does not nullify that consent. That consent stands, whether it was needed or not. Notwithstanding that, at the time of the 2015 application, the council had made a decision that an EIA wasn't required. However, that decision, we sought advice from Welsh Government regarding that. We also had a third party seek advice from Welsh Government and actually asked the application not to be determined until that advice was received. And Welsh Government at that time advised that EIA was not required and it was a Schedule 2 development. Now, subsequently to that, and subsequently to it being approved, there has obviously been a change of decision. Whether that was right or wrong, the council took what it felt was the only steps it has was to basically speak to Welsh Government and ask Welsh Government for a decision on the process, as did, I believe, Friends of the Earth as well, who were the other party who asked for that. Unfortunately, the decision that came from Welsh Government wasn't, it appears, correct at that time. The application was determined on the basis of that advice, and that advice was read out to committee at the time the application was determined. You can take from that what you like, and there isn't little more we can say on that matter. But actually, the fact that it was determined without an EIA does not actually render the application or the approval of that application invalid, and the application remains valid. It could have been challenged at the time. However, the time for challenge has now long since expired, and therefore, if you like, that consent remains in place. However, they have not implemented that consent. So to actually implement that consent, they either have to revert back to what was approved in 2015 in exact terms, which, to be honest, is almost impossible because, as Ian alluded to, there are a number of items that were missed off that consent, or they will have to go through the process of the appeal or another application, which will, of course, be picked up through the process now with an environmental impact assessment. So, just to clarify, the fact there wasn't an EIA at the time in 2015 does not render that consent invalid.
Right. So
James, hang on a minute. James Doherty wants to respond to this as well.
I think it was just a slip of the tongue from Marcus there. The 2015 consent was implemented, but it wasn't built out in complete accordance with the planning application, the planning permission that was given.
Thank you for the clarification, James. Ian, you wanted to comment, Councillor Perry, you wanted to comment further.
Yeah,
we need to stick to can I just encourage you to stick to the point of this matter, which is the enforcement notice?
Yeah, that's that. Well, so just a bit of clarification. So from what Marcus just told us, had there been a challenge in judicial review just after the decision was made regarding lack of EIA, then that could have been done. But that wasn't done. Is that what you're saying? And so that as time has passed, then you can't then go back and challenge at judicial review.
Yeah, there's a legal period within which a judicial review should be launched. We can't make a decision on what we can't even comment on what would have or wouldn't have happened if one had been launched, because there's no guarantee there would have been any change. But you have a certain window within time after a decision is made through which a judicial review should be launched, and that didn't happen in this case.
Yeah, because are there similar plants elsewhere in the UK owned by the same company that we could look at what's happening there and compare?
I believe there are similar plants elsewhere in the UK operated by this company. They have, in the time of the past planning application, offered to take members there, and members didn't want to take it up at that time. I think we're not talking about a planning application at the moment. We are talking about the enforcement notice, where we do have planning applications in, and that might be an option that members may want to take up at the time before considering those planning applications which are in, if they are considered in advance of this enforcement action and enforcement appeal. And that option would remain open, and certainly to see, if nothing else, a presentation about how those plants operate or whatever. But that would be a matter for members at the time of an application being considered. That's not what we're doing now. We are considering these changes to the enforcement notice on the basis of legal advice.
Okay, yeah, because that would be useful going forwards.
Right. Given that, I see no other hands going up, so we need to make a decision on these recommendations. Oh, there's another hand gone up. Councillor Hodges. and Councillor Perks.
Thank
Councillor
you,
Hodges first.
Chairman.
Go on, Nick.
Yes, thank you, Chairman. I've been waiting because I've been trying to listen and make sense of where we are and why we're here and what we're expected to do this afternoon. I was in the 2015 meeting. Now, I will hark back to start with because I think it needs to be put in a general context of where we are. There was an argument that there should have been an EIA, and we were told quite categorically that there was no need for an EIA, and therefore, as a result, we couldn't discuss things like the type of wood, the pollution aspects, and various other aspects of the incinerator. But there we are. Application was granted without the EIA, and finally, our minister comes forward and says that one is needed. So that's another interesting aspect of the whole kit and caboodle. But let's drill down into where we are with the enforcement action. This is a company that was granted a planning permission, and they spectacularly failed to build it according to what was granted to them. Now, I respect that they have a right of appeal against a planning permission, or in this case, an enforcement notice, but it's only right and proper that we defend our position and defend it robustly. This was built wrongly. I am not convinced, and I remain to be convinced that the plant, if it was allowed to operate at present, would be safe. Therefore, our enforcement action. I am not also convinced that even if the company was allowed to revert back to the 2015 application that was granted and build accordingly, and I struggle to see how they can, that would be necessarily safe either. It leaves me with little optimism that this company is able to deal with the situation that they've built and they are culpable of, and the situation that they put us in now. I really need to be convinced, and I'm still waiting for a proper argument of why we need to adjust the enforcement action that we have in front of us. I think it's clear. I think it is definite, and I remain to be convinced that it is not defendable at an appeal without more information, and that's what I'm looking for, Chairman. Thank you.
Okay, I'll bring in Councillor Perks as well to ask her question or make her comments, and then Ian, you can respond to that. Sandra?
Thank you, Chair. I just wanted to ask what the outcomes would be if we don't go with the officer's recommendations. So per se, if we didn't say that we would adjust the enforcement, how we wanted to enforce it, just what the various outcomes that PEDU could have, what they could do if we don't.
Thank you, Councillor Perks. I'll put that then to Ian Robinson for a response.
Thanks, Chair. Those 2 points go well together, because the point I was going to make responds to Councillor Perks as well. Just firstly, on what Councillor Hodges said, I fully appreciate how kind of building something wrongly can diminish people's confidence in the operation of a plant, and quite often with planning applications we have that kind of thing put to us. Imagine a takeaway operator who proposes to close at 10 and on all their other takeaways they've let open until 12 in breach of conditions. You don't have faith that they're going to operate, and the same principle applies here. And developer needs to try and secure a public faith. And I understand why that plays in members' balance of the issues. Unfortunately, we can't base our decisions based on how trustworthy we think the developer is. We have to assess the application and the proposal on the ground, not who's proposing it. That said, though, in the context of understanding where that sentiment comes from, in terms of the options and what the outcome would be if this weren't agreed, again, we're giving advice on what we would considered to be a likely suite of options that PEDU have, but please members bear in mind that we're not PEDU and we're not making those decisions, but this is we have a thought process on what the options could be. In theory, I suppose the developer, the inspector could say, fine, I'll leave the notice as it is. I believe the breach is described accurately, and I don't propose to make any modifications to it, and continue with the appeal accordingly. My own feeling, I guess only my opinion, but my own feeling is they probably don't think the breach is phrased as well as it could be, hence writing to us. I think if they felt there was no issue with the way it was worded, I doubt they would have written to us, but I have to emphasise that that's my opinion. Secondly, if the decision tonight was to not support the amendments, it's possible that the inspector could still decide to vary the notice if they felt there was no prejudice to any party. Or thirdly, if they felt there was a problem with how the notice was worded and the council were not taking the opportunity to kind of sign up to dealing with that problem, if they felt that was quite a fundamental problem with how the breach was worded, it's possible the notice could be quashed. Now, I can't say which one of those the inspector would do, but my advice would be that amending the notice as suggested would minimise the chances of the third option happening. That would be my opinion.
Thank you. Marcus, you wanted to comment on that as well?
Yeah, and I think just to say that on top of what Ian has said there, we recognise this is a very legalistic issue, which is why we sought at last minute, very urgent advice from the barrister who's advised us previously on this matter, and they've concurred with the approach that Ian has suggested there, that the PEDU wouldn't have written to us if they didn't have some concerns about the way it was currently worded. As I said before in my preamble, that it is often the case that this happens with enforcement notices, and it is, if you like, PEDU's attempt and the planning inspectors before them's attempt to get to a sort of a position where they feel legally both parties are in the same place. If they can't do that, they do have the option of quashing the notice and saying go back to start and start again. So I think this, is being recommended to you because it's the advice we're receiving from both our in-house and external lawyers in this respect.
Thank you, Marcus. Sandra, you want to come back and ask again?
Thank you. I think as much as this pains the committee with the to and fro we've had from this biomass plant and sort of the various different difficulties over the planning and it not sticking to the planning permission that it was given, I take on board what the legal advice that we've been given, both the internal legal advice and the external from the barrister that's previously worked on this. So with that, I propose that we move officers' recommendations.
Thank you, Councillor Perks. I'll second that. And I see no other hands up. I don't know if we need to move to a vote or whether people are happy with supporting our officers' recommendations. Councillor Perry, are you indicating you're happy, or are you indicating you want to move to a vote?
Yeah, I think we should go to a vote on this. I'm not entirely happy.
Okay, we'll move to a vote. Mark, if you can take us through the vote, please.
Okay, Chair, I'll go through list of members alphabetically, and obviously this will be for or against the officer's recommendations with regard to this enforcement action.
Absolutely.
If we start with Councillor Bruce.
I'm very confused, Councillor Bruce, but I'll go for.
Thank you.
Councillor Buckley's not here. Go on to Councillor Cave.
For officers' recommendations.
Councillor Champion.
For officers' recommendations.
Councillor Cow.
Against officers' recommendations.
Okay, thank you, Councillor. Councillor Drake.
For.
Okay. Councillor Ernest,
For the recommendation.
Councillor Gilligan,
For the recommendation.
Councillor Hodges,
Against.
Councillor Johnson,
And Erbyn against.
Councillor Payne. Right. Councillor Payne, are you here?
She doesn't appear to be with us. So.
Okay, that's fine. We'll move on to Councillor Perks, the Vice Chair.
For officers' recommendation.
Councillor Perry.
Against.
Okay. Councillor Stallard.
Obliged. For.
Okay, thank you, Councillor. Councillor Thomas.
For.
Councillor Williams.
For.
And finally, Councillor Wilson.
For.
Lovely. Thank you, councillors.
Thank you all.
I'll just top the figures up. I make it 11 for, Chair.
Yeah.
And 4 against.
Absolutely. Yeah, I agree.
Okay. So the recommendation is carried.
Thank you very much for that. Right. Thank you all for that. I think it was again an interesting discussion and so forth. We come to agenda item 10, which is any items which the chair has decided are urgent. I don't have any. There's nothing under part 2, so that's the business of today completed. Thank you all very much, and hopefully the weather will improve and we'll all have a decent few days coming up. Nice to see you all. Take care.
Bye all.